and our several students of International Anti-Corruption Academy, of our master's programs like Masters in Anti-Corruption Studies, International Masters in Anti-Corruption Compliance and Collective Action, Masters in Anti-Corruption and Diplomacy, Ayaka alumni. I, Pawan Kumar Sinha, am Director of Academic Programs. Welcome all of you to this very important panel discussion happening for the first time in this year with very distinguished panelists and our moderator, Mr. Mark Worth. How to shield workplace witness from retaliation. And this has to be done within the realm of the whistleblower protection system. Of course, when I say system, it encompasses legal instruments, the implementation mechanism, the redressal and judiciary mechanism, public awareness, which includes culture and norms, and including people at large. So this whistleblowing, in fact, has proved to be very effective in many cases worldwide in unearthing very complex corruption issues, the hidden schemes of corruption, and various regulatory infractions within public and private sector. Yet the protection of whistleblower continues to be a mammoth challenge in most of the jurisdictions. It undermines the effectiveness of whistleblowing as a potent tool to detect corruption cases. Experts believe that COVID-19 has heightened the risk of corruption and fraud, and the need for whistleblowing policies and the programs, and to enable people to speak up. So this is the chance for us to look forward and to understand from the experts how whistleblowing protection, the whistleblower protection, can be done without harming people who actually come forward with their information. I'm sure this information will be very useful both in public and private sector and help the society at large. The moderator of this virtual panel, as I mentioned, is Mr. Mark Worth. He has been working with whistleblower for more than 30 years as legal advisor, policy analyst, investigative journalist, campaigner, and a spokesperson. And he is a spokesperson for international whistleblower community. He is the founder of many organizations and campaigns, including Whistleblowing International, European Center for Whistleblower Rights, the Center for Whistleblower Rights and Rewards, and Southeast Europe Coalition on Whistleblower Protection. He has supported and advised hundreds of whistleblowers, investigated their cases, and advocated for reforms and justice based on their disclosures. He has worked for many NGOs in Europe and in US, and is an award-winning journalist and publisher. He has advised countries in all regions of the world and many international organizations, including UN, EU, APEC, OECD, Council of Europe. So this is a chance for all of you even to raise questions when the panel discussion takes place. And of course, we will keep you reminding. Before I hand over the floor to Mr. Mark Worth, let me tell you something about Ayaka, International Anti-Corruption Academy. It is seated in Austria. And this runs its academic programs and training programs for all those who have not heard about this institution. Please visit our website, www.ayaka.int. We have three master's program, as I mentioned, the Master in Anti-Corruption Studies, which started in 2012. International Masters in Anti-Corruption Compliance and Collective Action, we started in 2017. And in 2021, we launched Master in Anti-Corruption and Diplomacy in collaboration with UNITAR, that is the research and training wing of United Nations. Recently, we have also launched two very interesting programs. One is Postgraduate Diploma in Anti-Corruption Enforcement, which is 90 credit program. We have just launched postgraduate certification in whistleblower protection. And of course, I know the panelists will speak something about it. Or maybe at the end, we will have a short video program. Please stay back for 1.5 minutes once we finish the panel discussion as such. And we have many other training programs, Executive Diploma in Anti-Corruption and Diplomacy, again with UNITAR. And if you go to our website, you will see a lot of online open training programs and tailor-made programs which Ayaka can deliver. So after COVID-19, we have reinvented, I must say. We have started building up new programs so that we can reach to every corner of the world. And that is the mission of Ayaka. And I'm glad that the panelists who are here today are part of it. Mr. Wirth and his team has taught our master's program recently. And I'm sure that we will go ahead with many more things to come. So with this, I will hand it over to Mark, to you. Please, floor is yours.
Great. Thank you, Pawan. Thank you very much for that very humbling introduction. I'm speaking to you from Berlin. A very stormy day here in Berlin. We have sort of a hurricane, actually. But it's great to be with you today. The fact that more than 400 people registered for this event today is almost historic. It really shows how many people know about whistleblower protection and the concept of whistleblowing, the importance of it, the critical role that average citizens play in exposing and combating corruption and holding guilty people to account. Without regular citizens who witness corruption, witness crime, witness climate violations, illegal timber, illegal fishing, environmental violations, food safety violations, water safety violations, unsafe school lunches, without the contribution of regular people, regular ordinary citizens to expose unhealthy or illegal activities in our world, we cannot have democracy, we cannot have law enforcement, we cannot have accountability, we cannot have a clean society. I would imagine that most people watching today fall into several categories of professions, and we have a poll. So whoever is in charge of the poll, if we could have the poll posted, we want to know what your job category is. Do you work in a compliance staff, perhaps at a company in the private sector? Are you a practicing attorney? Are you a public official or work for a government agency? Do you work for an NGO or a CSO or an academic institution or some sort of a hybrid of both? Are you a journalist? Do you work for a media organization? It's really helpful for us to know, not just for the purpose of this event today, but also in terms of who is working on this issue. Where is the demand coming from? And I see a big spike here in compliance staff. That could largely be due to the passage in 2019 of the European Union Directive on whistleblower protection, which actually required the 27 EU countries to pass a new whistleblower law by last December, just 2 months ago today. Only 7 countries have, but this directive, as many of you know, requires companies over a certain size to set up some kind of whistleblower mechanism, to have this be functional, to have a designated person in charge of whistleblowing. So I'm really speculating that now we have more than 1/3 of people with us today working compliance, which I think is terrific, because many reports, in fact, in some countries, up to 90% of whistleblower reports in companies are reported internally within the company to compliance or to HR, or if there's an audit function, an audit committee. So that's just terrific. And I'm very happy to see so many activists and so many public officials and practicing attorneys. We are here today because tens of thousands of people, perhaps even hundreds of thousands of people, every year report crime and corruption from within their workplace. This is what a whistleblower is, somebody who has a job, and most wrongdoing does occur in some kind of a workplace. And very few, if any, of these people have swift and reliable protections from retaliation. As Pawan said, many laws are passed, but the implementation and the enforcement should be improved. We all read about the new whistleblower laws being passed, and the articles and the studies make them look really good on paper. And we now have more than 50 countries worldwide that have some kind of whistleblower law in place. As of the year 2000, we only had 2 or 3. Now, 22 years later, we have more than 50. It's been a revolution in the broadening and strengthening of free speech rights for witnesses in the workplace, especially. But most of these laws have, frankly, an appalling record when it comes to functioning in real life cases. This is what the three of us, myself and Stephen and Boris, do every day for a living, is to make the most out of these imperfect laws and to use our creativity and persistence to help people who are punished for doing the right thing. And that's what whistleblower retaliation is. It's regular people who witness a crime using their human instincts. The instinct is to report it to somebody who could fix it. And then they are quite often punished because of retribution from their colleagues or managers. We're here to talk about how to actually help people in real life situations. And we have these laws, we have these mechanisms and hotlines and procedures, but a lot of the work that we do doesn't really depend on laws or courts. We have to use our softer skills to help people who are in a crisis or in an urgent situation. And these cases fall in different categories. And just in this past week alone, I've had 3 cases that fall into different categories. One person was a whistleblower who has not been dismissed yet. We're trying to save his or her job. Another person has been reinstated to their job, but is not yet back to work yet in a new position. And we're working with her right now to get her new job back. And the third case is somebody who has been reinstated and is back at work, but their person is still facing difficulties from the company, which is a very, very large multinational company. So the person feels intimidated that after winning the whistleblower case is back at work, still facing some discomfort in his or her position. So these are the kinds of things that laws don't really address, is the real life situations that people find themselves in. We help them with their cases as much as we can. If the law is applicable, we help them go to court to protect their free speech rights, but this can take a very long time, and we're going to talk about that later. It comes down to the will and tenacity of not just us as whistleblower caseworkers, but of the citizens themselves. And we assist and support, and also from the assistance and support from our organizations together, our creativity and tenacity and the creativity and tenacity of the whistleblowers is what can help them to have a good outcome for their situations. We're going to be talking a lot about these and many other strategies today with using examples. These cases are hardly ever neat or simple. In my many, many years working with whistleblowers, not one of the cases has been simple. They're always complicated and lengthy and with many different people. You have to have a lot of skills with conflict resolution and mediation to just try to get the situation closed as quickly as possible while limiting the damage. The cases are, as I said, are messy and take a long time. And the cases are usually painful. Somebody generally does suffer some kind of loss, or even in the worst case scenario, a personal disaster. Right now, I'd like for you to send your questions and comments before we get started. I know a lot of people are out there listening and watching. We want this to be interactive. We want this event to be led by you, the practitioners who are working in this field or who want to work in this field. Please start sending your questions right now through Zoom, and we will keep track of these and answer these questions as we go. So right now, I want to introduce you to my 2 very good friends. Stephen Cohn is a founding partner of the whistleblower rights law firm of Cohn, and Colapinto, LLP, and also the co-founder of the nonprofit National Whistleblower Center, both of which are in Washington, D.C. This law firm won the largest ever whistleblower reward in a tax evasion case involving UBS banker and whistleblower Bradley Birkenfeld. And the Cohn law firm also represents Danske Bank whistleblower Howard Wilkinson, a case that you might know, which is believed to be the largest money laundering scandal in the world's history. Stephen has helped draft many key whistleblower provisions, including in the famous Sarbanes-Oxley Act and Dodd-Frank Act in the United States. And he has advised many public officials around the world, has testified before the European Parliament, many other parliaments, and he's the world's most published author on whistleblower protection, including the wonderful and very readable new Whistleblowers Handbook. And Mr. Cohn also teaches whistleblower law at Northeastern University in Boston. Boris Vukasinovic is the deputy director of the Montenegro Agency for Prevention of Corruption, the official anti-corruption institution for the country of Montenegro. Boris is responsible for the most sensitive anti-corruption topics in the country, including whistleblower protection, political party financing, integrity building, and lobbying. Mr. Vukasinovic has held positions at national and international NGOs as a legal expert and has been a member of several task forces responsible for rule of law. He has a master's degree in economics and a law degree from the University of Montenegro, and his main research interests include multidisciplinary approaches to investigating the origins of corruption and defining the most effective methods in combating corruption. So you see the broad background that is needed to help whistleblowers in real life situations. So I'm going to turn the panel right over, but please send in your questions. I see a couple of questions are coming in. We're going to get to those questions immediately. Here's a question from Elka Strang about, yes, I think we can answer your question very quickly, but first let's pass it over to Mr. Cohn for his remarks. Stephen?
Thank you very much, Mark, and thank you to the Academy for this great program. And Mark, when you can, if you can share the polling results, I'm interested in knowing the professions of most of the participants. And then you may want, if you can post the PowerPoint. First off, I want to say that the debate on whistleblowing has shifted from whether whistleblowing should be protected to what types of protections whistleblowers need. The reason for that is there's been study after study after study that whistleblowing works. It works as the single most important detection mechanism for all forms of corruption. So if you have a very effective tool, you need to know how to use it. And just so all the participants know, the major international organizations have all come around to adopting and supporting whistleblowing. The IUCN, the most important environmental group, has endorsed it and endorsed whistleblower rewards. The OECD has praised Foreign Corrupt Practice whistleblower program. The UN has just come out in support of it. The United States, the official US strategy on transnational corruption is right behind whistleblowing, and we all know, or many people know, the EU directive. So let's go to the next slide, please, Mark. So this is a quote from the leading senator in the United States about whistleblowing. Once it pops up, can you get that? And it's pretty obvious what it says, which is, going after waste, fraud, and abuse without whistleblowers is about as useful as harvesting acres of corn with rusty old scissors. Next slide, please. But what we know is, why would anybody ever blow the whistle? It's not a good move for your career. And in this breakthrough study, that was their finding. Their finding wasn't that there were whistleblowers. They couldn't figure out why anyone would ever do it, given the downside. And that's really one of the biggest problems. Next slide, please. But what has occurred both in the United States and worldwide is this recognition about how important whistleblowing is. This is a quote from the former Attorney General, that it False Claims Act is really the oldest and most effective whistleblower law in the United States, and I think worldwide. And it says it's an essential tool to combat fraud. Its impact is profound. Next slide, please. And this is again from the Assistant Attorney General responsible for enforcing whistleblower program in the Justice Department. He described it as the most powerful tool. So you have this problem where you have the most powerful tool to fight corruption, yet no one wants to do it because you get your head cut off. And let's just say, talk bluntly here. Who likes to be told they're violating the law? If a whistleblower reports up and they're right, and there's a major criminal or civil infraction, who wants to hear that? What's the human response? Next slide, please. And I want to say, I'm asking the Academy to post this and make this PowerPoint available. I won't be able to go through the whole thing, but there are links to all of the Q&As on all the major issues on whistleblowing, and most of the sources here are all linked. So this is what occurred when they did the False Claims Act in the United States. And I'm pointing to this because the False Claims Act has very specific procedures which encouraged whistleblowing. So when you're looking at how should I set up a whistleblower program, or what does it take for a whistleblower program to be effective, the starting point should be the False Claims Act, which combined a carrot and a stick approach. The carrot was strong anti-retaliation, and you can look at that and what it guarantees. A reward system to incentivize people coming forward, and increasing the penalties for engaging in corruption. So if someone implements this law, they put in a provision that automatically increases fines and penalties by threefold. It's a trebling damage, because they knew that it's not just enough to report the corruption. If you get caught, there needs to be an effective remedy. And what you see here is this law was amended it became effective in 1987. And you can see at the beginning of this law, and this is in billions, you can see the blue line is the government collections on corruption cases. This is how effective the government program was without whistleblowers. You can see how much they were getting. So, then you see the orange line, which is the whistleblower, what was coming in on the whistleblower cases. So obviously when the law was first passed, whistleblowing was new. No one knew how it would work. It was an experiment. But then look what happens over time. When you come to 2020, it's over 85% of your anti-corruption cases and recoveries are coming in from whistleblowers. Now remember this, the non-whistleblower are all your auditors, your compliance people, the FBI, the Justice Department, the entire massive bureaucracy designed to catch fraud. And the whistleblower are employees working for free. So, and you can see, and this is why everything changed in the United States. And this is what's driving this whistleblower movement internationally. Because it's just there. If you want to be effective in fighting corruption, having compliance, this is it. Next slide, please. Now let's talk dollars and cents. The US Department of Justice publishes annual statistics on how the False Claims Act works. This circle here is telling you that since the law is amended, whistleblowers brought in $40 billion in sanctions. 40 billion. That's like a lot of money. And they paid whistleblowers $6.5 billion in compensation. The law just took off. Next slide, please. Now, Mark is telling me we have a lot of questions. I'm going to hit two other little points here, and then I can answer a question or two. So this is the basic framework for an effective anti-retaliation program. There's a lot more to fill in, but if you don't have these four basic pillars, don't blow the whistle. It's like crazy. First, you need a clear definition of what is protected. An employee needs to know what they can say and who they can report it to, clearly spelled out. Second, the retaliation laws all focus on protecting an employee's job and career. So each law has to be tailored to have a realistic ability to protect the job. Why? It's obvious. No one likes to be told they're violating the law. Retaliation is almost a natural response to a major whistleblower disclosure. You can't hide from that. You have to address it. The third is called just basic due process. Nothing works unless the rule of law can be applied. And I say one place to always look is for personal injury violations. Our better laws really mirror, they view retaliation as a personal injury, the same as if someone walked up to you with a baseball bat and smashed you on the head. What are your rights if someone smashes you on the head? Because that's what whistleblowing is, retaliation psychologically and to your career. It's a baseball bat, you're smashed on the head. What are your due process rights? And last but not least, you have to look at the damages. That's the last pillar. Because if you're going to take the risk, what do you get? One last slide, and then we'll hit those questions, Mark. To the next one. So the next one I'm looking at are the reward laws. I'm mentioning this, and if we have time, I'll get into it. These laws are transnational. Over $10 billion in sanctions have been collected from non-US companies operating internationally. And whistleblowers have received hundreds of millions of dollars in rewards. When you look at the PowerPoint online and go into the Q&As, you'll see all the details. But because so many companies are transnational, banks, and they sell on Wall Street, they sell to stocks. It's really not easy, but very doable for whistleblowers around the world to qualify for awards. And this is what you see here. First off, these programs usually have a confidential reporting structure. Retaliation, the company knows who you are, they're retaliating. These laws have figured it out. Create a mechanism that no one ever knows you blew the whistle. And I am here to tell you my largest case ever. The company never knew there was a whistleblower. Properly implemented anonymous and confidential reporting structures work. Second, it shifts the entire case to the quality of the information. We're not going to sit and litigate whether the employee came in late 5 times and wait, which often can just be a distraction. Do you have evidence of corruption? If the answer is yes, get it to the right people. And if that evidence is strong enough to prove a case, give them a reward, which is the third pillar, a compensation, because you can't get compensated if no one knows who you are, if you're anonymous and confidential. So you need a way to compensate people for taking the risk of having their lives destroyed. And down below, these are some of the laws that have major transnational application that all have rewards, and information on them is all linked there. So I'll end my presentation. I'm not sure how much more time I have, or if I went over my time, Mark, but you told me there are some questions. I'd love to take a question.
Yeah, we're going to come back so you can finish, but we're going to do a lightning round. And I want Boris and Steve to give quick answers. I'd rather have shorter answers so everyone's questions are addressed. Here's one. I understand that whistleblowers are protected against being retaliated against for making a report. What about whistleblowers being retaliated against for other infractions that are searched for after the whistleblower is identified?
Yeah, so absolutely. So once almost all retaliation occurs after the whistleblower is identified, because before they know who you are, they don't know who to get. But once they know who you are, it can happen. And that retaliation can happen a year later. They can sit and wait. So the answer is all effective anti-retaliation laws cover violations well past the initial disclosure.
Good. Here's a question. What is the best way to stay safe? I think Steve talked about anonymity, or if you're dealing with a lawyer, there's confidentiality under attorney-client privilege. The best protection, I'm going to steal Steve's line. The best protection is anonymity, period. My mantra is blow the whistle, but don't become a whistleblower. We have a mythology, a folk hero narrative being developed around whistleblowers. The media loves these stories. In 95% of the cases, at least, there is no reason. It doesn't help anybody for the person to go public. It's a great story for the newspaper, but the next day they forget about you. So we work extremely hard, and Boris and Stephen, to keep the names out of the newspaper. If the case is already public and I'm writing about the case, I don't mention the person's name again, even though the name is already out there. So anonymity or confidentiality for me is the most important thing to protect people from being hurt. Here's a question about other studies on special laws on corruption that were effective. Steve's PowerPoint talks about the effectiveness of the American laws. We have studies on this. The Government Accountability Project has studies on this. Please send me your email address and I will send you those studies. Here's the question.
Mark, just on the studies, I think now the most important one was done by the OECD Phase 4 report on United States Foreign Corrupt Practices Act. So the FCPA has both an anti-retaliation provision that's very good and a reward provision that's very good. The OECD auditors were all non-US people that came in and did a detailed audit of the program. They came out in strong support of the Dodd-Frank Act whistleblower program and praised the United States as the #1 enforcer of anti-bribery worldwide. And as I said earlier, billions in sanctions from non-US companies.
Right. Here's a question about official secrets. Many countries are setting up special channels and offices to deal with whistleblowing related to national security, official secrets, classified material. Steve or Boris, does anyone want to, do either one of you want to comment on a way to make sure that wrongdoing is reported to the right person, but that any risks to national security or military secrets those risks are minimized?
Hi, Mark. I can answer on that one. That depends on the system. For example, in my country, what's happening is that employees from the Agency for Prevention of Corruption can actually approach to these secrets. So we cannot make a public disclosure about the special case, but we can handle all the material from the case. We have the legal obligation actually to do so. So if somebody discloses any information in regards to the national security or something like that, we can take the material, we can do the case, we can finish the case, but we cannot actually talk about the case or give any details. So we can handle it.
And just to second that, the United States is the same way, and I recommend it to any country. For classified or confidential information, you need just a very clear law with a specific office to collect that information and deal with it within the confines of the law. Other than that, it's going to be a disaster. And we have many examples in the United States of people not following the law and really having their lives ruined.
But I think after Edward Snowden, Steve, didn't the Congress pass a intelligence community whistleblower act of some kind?
Exactly, but again, it sets up a specific office,
right?
A specific procedure to do it, and that's
very important and a very good question. Here's a question about the perception of rewards in Europe. I can tell you it's changing, it's opening. We now have 18 countries in the world that have a whistleblower reward system of some kind. Montenegro has one, right, Boris?
That's right, we have the system, but basically the state is not giving any rewards. Reward can be given only by the entity where is the whistleblower from. You know, if whistleblower by reporting is saving the money, let's say for some company, that company can or may reward him, but it's not actually obligatory.
Right.
And let me just weigh in on that question, Mark.
Well, let me quickly finish. There's also reward programs in Slovakia, in Ukraine, in Lithuania. It's picking up steam as people realize that the normal compensation mechanisms through the courts don't work. People need to be incentivized to come forward. And Steve has said, and maybe he can comment on this, that one of the keys is to make the rewards mandatory. So the rewards have to be paid. So they can't be, like Boris said, they can't be discretionary, that the rewards must be paid.
So let's just look at, again, the empirical data. United States has the good reward laws. They're mandatory, and they set up, as that you see here, a percentage of the sanction. So the bigger the scandal, the better the evidence, the more the reward. Now, Europe and the rest of the world is way behind on this, way behind. That's why we've had over 5,000 whistleblowers from 130 countries use the US laws. We've paid hundreds of millions of dollars to non-US citizens. Today, the majority of my cases are non-US. Look at some of the laws on this slide, it's still up. The Foreign Corrupt Practices Act are bribes paid by corporations, any publicly traded corporation, whether it's on the Paris Exchange or the New York Exchange, to a foreign official, billions collected. The Commodity Exchange Act, the worldwide trade in commodities. How big is that? And it's transnational. Money laundering through the banks, transnational. So our laws pick up where other countries have failed to implement effective laws. I can't emphasize this enough. These laws are open, they work, and really, I believe they're going to be the laws that push other countries to do the right thing. And let me just tell you how crazy it is. A whistleblower in America under commodities got a very large award, over 100 million. But guess they actually collected a percentage of the sanctions obtained by the FCA in Great Britain. Under the Commodity Exchange Act, our government can pay awards if foreign commodities regulators issue the sanction. So the transnational scope of these laws is just, we're pushing them as far as we can. Let's hope other countries follow suit.
Here's a question about the effectiveness of whistleblower laws in developed countries versus developing countries. In my experience in Eastern Europe, many of these systems are working better than in Western Europe or EU countries. There's more, and what you might call developing or transition countries, there's more of an emphasis on anti-corruption, more resources from international organizations, more media, more citizen demand for cleaning up corruption, as opposed to the old crusty countries in Western Europe where whistleblowing does not work at all. We're seeing a lot of successes in Eastern Europe, in Asia, a little bit in Africa. It's picking up in Latin America. I can tell you, living in Germany for 15 years and being to every country in Europe, the Western European EU countries are much less interested in this concept because they think everything is great, which it's not. So I would say that many of the things that work in the United States can be translated to work in developing countries. And Steve's principles are very applicable anywhere. And we can, if you send me your email address, I can send you some more information.
Mark, on this question, I have one slide, and then we can just get rid of the slide point, but it's so important to address this issue. If you can just start going down, I want to come to this slide because it will really respond to this question. And I'll tell you, if you can just start going down, it's going to be about 5 slides down. And what it does is we've looked at where the reports are coming from, where the corruption is, and how it's all getting paid out. Just stop right there. Back one. So what you're looking at here, no, go back. Here it is. The countries in black are where the companies that are paying the bribes are. You can see it's the developing world. The companies in red, I call them the victim countries. They're where folks in the black countries are coming in and bribing up and destroying democracy, destroying the rule of law, undermining development in all the developing countries. Now, then there's a couple countries which have both their businesses have paid bribes and they accept bribes. Those are the ones in whatever color that is, purple, whatever. So, but what we have seen with the whistleblowers, so whistleblowers from South Africa, from Nigeria, the Congo, Argentina, Brazil, that have the evidence that that the bribes are being paid, they become whistleblowers. They can use the U.S. confidential reporting, get a reward. Almost all of these countries in black, the companies that are paying the bribes are covered under our laws. So this is the reality. So some people think that, say, a country like France or Germany is going to be more advanced in anti-corruption. But in reality, many of the most important economic powers in those countries profit from corruption. So our new laws have created a dynamic where, yes, someone from France can use this law if they're concerned, say, about a bribe being paid in India, but someone from India can use the law to report the company from France. This is the new transnational map of anti-corruption and how it's playing out. So developing countries with no rule of law, their whistleblowers have full access to the new international programs.
That's an incredible map, Steve. Thank you for sharing that. Here's a question from the UK. What advice in the UK to have a new whistleblower law? I would say replicate the directive, the new European Union directive, but also add a special whistleblower office that has the authority to order somebody to be reinstated, protected, or compensated, have rewards, and have penalties for retaliation. We need to further penalize retaliation as a workplace hazard. Some countries have criminal penalties for retaliation. A man was arrested and criminally charged in Malaysia for retaliating against somebody in the workplace. I don't necessarily support criminalizing that, but if it's egregious enough, why not? But certainly, we're not going to stop retaliation until there is a strong deterrent against doing that. So strong penalties for retaliation, a whistleblower office, like what's set up in Montenegro and in Slovakia, and rewards and copy the directive. I'm going to do one more question. Here's an interesting question. How do you protect people who don't make a formal complaint? Person does not file a formal complaint and maybe goes through mediation or negotiation, but there's still retaliation. That's interesting.
It's very interesting question, Mark. I hadn't thought about it, and in our system, it's impossible to protect anyone who didn't comply formally. You know, you have to make like a formal reports and then go from there. If it's not formal, if it's not written, then it's not a report basically. So it's really difficult to provide any kind of protection in that case.
I mean, this kind of raises the question about retroactive protection. What if you're retaliated against? Can you then could there be a mechanism to protect somebody retroactively?
It all goes down to knowledge. If the company knows you are the whistleblower, then that triggers the retaliation laws. If the company doesn't know you were a whistleblower, then how can you be retaliated for whistleblowing? And in many of our cases, that becomes an issue where, based on the behaviors of the employee, did the company conclude that this person was the whistleblower with what's known as circumstantial evidence? So those cases do come up. And and in the United States, they've gone as far as to protect people who did not blow the whistle, but the company concluded they were the whistleblower through, that's just who they thought did it. So there are cases where those people have been protected.
I personally think that protection from retaliation in the workplace should be automatic, like with anti-discrimination laws. If you are discriminated against for being a certain gender or ethnicity, or if you're pregnant or a certain religion, if you are a member of a certain religion, a certain denomination of a religion, for example, and you get hired at a job, you don't report that to some office saying, oh, I'm XYZ religion, I'm registered as that, and then if something happens to you, you get protection. It doesn't work that way. You're automatically protected against discrimination. It's automatic. So I don't know how this would look in a real life piece of legislation, but I think that whistleblower retaliation is a workplace hazard that automatically should be protected and punished. I don't think you should have to go through an office, a complicated procedure. It slows up the process. It allows companies to drag things out. So I would encourage anybody listening who's a public official or a compliance officer to have a mechanism where the rights are automatic and the things that the employee has to do to exercise those rights should be minimal. And this has been a big problem. The things you have to go through just because you opened your mouth and you are punished are quite excessive. We're gonna take a pause now and go right to Boris from Montenegro. Boris, let's hear what's on your mind today.
Hi again, Mark. Greetings from sunny Montenegro. It's almost always sunny here, unlike Berlin in Germany. So I will skipping introduction because you already did it. So I will try to be as fast as possible. So what we have to remember actually is that whistleblower protection is the fight against corruption in its essence. Providing effective legal protection and clear guidance on reporting procedures can help authorities and organizations to monitor compliance and detect violation of anti-corruption laws. Precondition for successful fight against corruption is a functional anti-corruption legislative and institutional framework, as well as continuous and consistent implementation of all strategic documents. In my experience, lack of results in this area is usually a consequence of an inefficiency of existing system and approach to this issue by the institutions and individuals. What I usually hear in the training and trainings and discussions and panels, as this one from young professionals who deal with the whistleblowers, is that I cannot change the system as an individual. And I say this is completely wrong approach, because this is exactly how you change the system, by starting from yourself. You never know what impact you can have and what you will have to the society. You mentioned that it's really, really important to have solid reporting channels. So any institution and the government and the state parliament have to create really solid reporting channels. And in that situation is almost impossible to disclose the whistleblower. Actually, you're keeping safe his or her identity, and then it's really difficult to do any kind of retaliation. For example, in my country, in the last 6 years, we had 550 reports and only 24 requests for protection of some of these whistleblowers. And the fact is that we are keeping those anonymity really, really safe, because we have a lot of reporting channels and we have the office, which is really isolated. So it's really, really solid ground. And usually those whistleblowers that are retaliated are usually the ones who go publicly. So they usually public disclose all the negative things from one institution, and usually what is happening is retaliation. So safeguarding public interest and promoting a culture of accountability and integrity should be a primary goal of all public servants. Public officials who deal with whistleblowers protection should be a true partner for those who report misconduct or retaliation. And in order to do so, they need to be supported by effective trainings, including developing awareness raising and really strong communication skill. Whistleblowers are certainly one of the most important mechanisms for fighting corruption. And as I see it, whistleblowing or making a disclosure certainly is not the same as filling a simple report or complaint aimed at protecting some individuals' rights. Whistleblowers are usually the messengers who draws the attentions about something much bigger than themselves. And they usually warn that something that is happening is illegal and unacceptable, which can be corruption, fraud, abuse, any kind of unethical behavior. That is something that require a reaction from the competent authorities, primarily the police and the state prosecution office. As you mentioned, they play a very important role in anti-corruption efforts, both globally and nationally. Because of this behavior, whistleblowers may suffer the consequences of retaliation usually by their superiors, which usually negatively affects future reports and as well as their well-being. Comparative legal practice shows that states are paying more and more attention to the protection of whistleblowers, both at the level of legal norms and the term of their implementation. What I can say is that I hope there will be political will to protect whistleblowers in Europe. New directive is a very good start, but directive is only theory, so we have to see in practice in some years to come. I'm not sure if all the participants of the panel are aware, but as we're speaking, if whistleblower is mistreated in the most of the EU countries, he or she doesn't have any place to go. So whistleblower protection does not exist even in some very developed democracies, which is unbelievable. Here in Montenegro, we have a good practice in whistleblower reports and protections. A legislative framework was set in 2015, and the Agency for Prevention of Corruption as a central body was established in 2016. One of the chapters within our law is dedicated to the whistleblowers. The law is very well aligned with the new whistleblowers directive from 2019, which is being implemented in the EU countries as we're speaking. And you probably ask yourself how this is possible when majority of the EU countries do not have legislation that treats whistleblower rights, how one small country from the Western Balkan does. And the answer is simple. We were the test ground for the legislation, experiment or trial to see if it works, and it does. We have a good example from the practice, which is very important to the media, public, and society. And I can say that we are probably the only country in Europe that one of our whistleblowers became a minister in the new government. One of them became the director of the governmental body, and one of them became the executive director of the state-owned company. So what I can say is that all public officials who oversee whistleblowers reporting and protection system should make a clear commitment to always keep eyes on the ball, because speaking up is really never easy. I will conclude with some recommendations that can be adopted at the state, regional, local level, or even as in an office which is dealing with this subject. So what you need first is the comprehensive analysis of the situation, along with realistic risk assessment in consultations with all relevant entities. In my country, this analysis showed what are the areas that are especially prone to corruption. And we came to public procurement, privatization, special planning, education, healthcare, local self-governments, and police. Secondly, you need to establish mechanism for preventing and fighting against corruption and strategic framework. Third, it's really necessary to clearly define which body at which level coordinates and monitors the implementation of activities in the area of fight against corruption. We have a clear system where each public and private body has to have a person or an office within its system which will be in charge for the whistleblowers reports and protection. At national level, we have the agency. Fourth, we have to prepare and adopt anti-corruption action plans, and then to prescribe a system for monitoring and realization of such an action plan, reporting and evaluation at the local and national level. And last, you have to increase the responsibility of persons in charge when we speak about whistleblowers report and protection. So I think I was short as possible, and I will try again with our colleagues Mark and Stephen to answer some of these questions.
Yeah, we have a question, Boris, about trust. How can there be trust that if someone comes forward, they're going to be helped? Now, your law has some great provisions on paper and in real life. It does not give you the authority to order a company to reinstate someone, but you can apply a lot of pressure. You can strongly recommend that somebody be protected or reinstated. If the recommendation is not accepted, you can go public or report this to the parliament and shame the employer to rehire the person. Why don't you give an example of how you've been able to pressure an employer to hire back a whistleblower or not to fire the whistleblower in the first place? And maybe the person who asked the question can understand that I think that only trust can be developed through positive examples.
Of course, the trust between the institution who is in charge for the whistleblowers protection and future and possible whistleblowers is really needed. We have a good practice already, so that trust is already established. We have a lot of reporting channels, so the whistleblower can choose which channel to take. They can go even anonymously, so basically that even the employees within the agency that work within this section, they don't actually know who the whistleblower really is, but that doesn't make any difference for us. So we have a lot of channels. We have we have a really specific number of people who can actually deal with these reports, and it's not a lot of people. So that's the key about the let's say the confidentiality. And regarding to our recommendation and reinstatement to the job, we had a lot of cases that we have the retaliation. We had one huge case that we fought against one of the we fought the biggest state-owned company within our country, which is a huge winery. And what happened is that they fired once a whistleblower who came back to us, and then we won the restyle. They took her back because we made a lot of pressure. What we did in that specific case is that her ex-boss refused to take her back to the job, and then we made a lot of media attention. We drove the media attention because the media is following closely the work of the agency, and we have a lot of good communication with media. So they pressured that company, and we also did some pressure through the parliament, through the executive board of directors actually of this company, and with all these elements combined together, we actually won that case, and they offer her job back. So that was one of the cases. And when you have one of such of cases in media, then other whistleblowers, actually potential whistleblowers, and somebody who actually think about disclosing some irregularity, it's a positive actually effect for them to come forward and then speak to us and see if we can help and in which way.
So Boris talked about pressure and transparency. Whether you're working at a compliance office or a government agency like Boris's, or even if you work at an NGO, pressure and transparency. The retaliators need to know that they cannot do this with impunity, that somebody's going to push back against them. And then if things get really ugly, that the case might go public and they will be shamed in their country and perhaps internationally. We do lots of naming and shaming. In our work, it's not fun. I don't personally enjoy it, but we have exposed the retaliators. We have named the I have written articles naming the retaliator, who was in charge of the retaliation. And this is the last thing they expect. The last thing they expect is for their name to show up in a newspaper article as being the retaliator, because they are not expecting pressure and they're not expecting transparency. So this comes down to, I mentioned in the beginning, will and tenacity. It's very easy to count the reports coming in and track your system and have nice statistics and data. But if you don't have somebody like Boris and his colleagues and have political support to have a dedicated budget, which Boris's office has, a designated staff who have been trained and are knowledgeable. If you don't have that in place, you can't apply the pressure and you can't maximize transparency for the benefit of the victimized witness. So that's a very good question about getting trust. It's like building your muscles. You have to start somewhere. It's painful in the beginning to do that first push-up, but we've had successes around the world in countries like Moldova, where the Ombudsman's office, in a very similar fashion to in Montenegro, has successfully protected its first whistleblower, actually from before the person could be dismissed. The Ombudsman's office intervened, put pressure on the employer, and the person's job was saved, and the person was not dismissed or retaliated against at all. So you just have to try it. I know that sounds simple, but if you wait for some magic trick to come along and do it for you, it's not. You have to take the initiative yourself. And even though you might get pressure from your colleagues, especially if you work in a compliance office in a big corporation, maybe there's soft pressure or explicit pressure not to help the employee. You have to stand up sometimes to your own colleagues and say, no, we're going to follow our code of conduct. We're going to follow our internal whistleblower procedure. We're going to follow the law in our country, and we're going to do what's right, and we're going to be transparent about the results.
Mark, I just read the really nice question, and it says, why would a whistleblower want to remain the organization at which they had reported? And I give a thought about it, and I think the answer is simple. Usually the whistleblowers especially the ones who publicly disclose something, they usually want to go back and to say, I was right, and I was really brave within this procedure, and I want to stay. I want to send a message to everybody that I was actually right, not let's say some manager or something like that. Especially within the huge organization, they change the management within this organization frequently. So those who were responsible for retaliation might not be in this organization when this whistleblower actually is back to the job. So we had also that kind of situation in Montenegro, that management is frequently changed, and all of those people who were responsible for retaliation are not within the system anymore.
Mark, on the prior point of shaming in public. There's a question about the role of the news media, and in countries that don't have effective protections, maybe that's the best route. And it really is a very good route. Just a couple points on that. Before the United States had very effective whistleblower laws, the news media was the #1 channel for people to raise concerns. And some journalists, or most, any with integrity, will honor the confidentiality of sources. Obviously, it's a high-risk operation. One thing that most people don't know is that because the news media was such a major source for whistleblowers, all of our whistleblower laws have incorporated media disclosures as a protected way to qualify for a monetary reward. In other words, if a whistleblower blows the whistle to the press, and one of the US government agencies learns about that allegation through the news media, that whistleblower can actually qualify for a reward. And we have a petition right now with the SEC trying to get them to fully implement that right. But the news media is a big deal and very important. I'll let that, there's one other question I'd like to answer, but I can hear if other people want to comment on the news media. Hearing nothing, there's another question came in about an accomplice in a bribery scheme. What happens to the accomplice who falls out of favor? Can they blow the whistle? The answer to that is absolutely yes. All of the good reward laws cover participants. The very first reward law in the United States, False Claims Act, when it was originally passed, actually in the American Civil War, they used the phrase, it takes a thief to catch a thief. Remember, the goal of the reward laws is to extract really good evidence to find people guilty. And participants in these schemes often have the best evidence. So if these laws can be used to flip a participant to become a government witness. Now, there are other ways that's done, you know, a plea bargain, a deal, immunity, but that's usually after that criminal gets caught. The reward laws try to go into the conspiracies themselves to people where the government doesn't know about the conspiracy, and these people have not been identified as crooks, to come forward with information. So yes, participants are great whistleblowers under the reward laws.
Also, Steve, there's two questions about third-party people or associates of the whistleblower. Many of the new laws cover not just the whistleblower, but people who may have helped them or people falsely identified as being a whistleblower, people who've helped the whistleblower. I don't know many real-life cases where that's been tested in court, but the European Union directive and all the international standards include that. We have to have these laws have to be broad enough that they capture every case.
Yeah.
Many people have lost because of a technicality, or they didn't qualify for some ridiculous reason. It has to cover all range of misconduct or perceived misconduct. Oh, you reported embezzlement, but this is fraud, you're not covered. Every kind of problem or misconduct in the public interest should qualify as whistleblowing. It shouldn't matter who you call, shouldn't matter when you called. We can't restrict speech, especially for crime. Imagine you see your neighbor's house is on fire. Thank goodness we have a 3-digit number you can call. Imagine you had to go through a procedure to find the right fire department to call, that the house is going to burn down. So anyone out there designing your compliance system, whistleblower system in a compliance office, or a member of parliament listening, or a public official, please make your laws as broad as possible so any type of report from any type of person is covered. Regular citizens are not lawyers. Yeah. Regular citizens don't have the knowledge to read these laws and look for loopholes. Everybody has to be covered as much as possible. Steve?
Yeah, so what you're saying about the broad coverage, and I see a question here about what about countries where a whistleblower may face physical danger or even being killed. The new laws, and this includes the anti-bribery laws and the laws on commodities corruption, which is mineral extraction worldwide, oil extraction, they allow what's known as an analyst to become the official whistleblower. So in countries that lack the rule of law, or where a whistleblower may face real risk to their life, this is a critical function because it would permit an NGO or an anti-corruption organization to be the intermediary to get the information, and then that NGO, through a representative, to file the information, doing everything in its power to shield from identification the initial whistleblower. So this concept of an analyst who can take other people's information and then forward it is a real breakthrough for anti-corruption and broadening the scope of these laws.
Here's a question about where the whistleblower protection system should sit. And maybe Boris can comment. The person's talking about how in some countries the whistleblower system comes under the Prime Minister's office. I'm not quite sure what that means. But Boris, talk about the institutional structure briefly about the anti-corruption office where you work and the independence of the operations and your financial resources.
Well, if it's a really, really good question. In my opinion, it shouldn't sit under the Prime Minister, because the most of the actually cases are going against the Prime Minister office, to be honest. So it's really important to have completely independent body. And our agency for prevention of corruption was established by the Parliament of Montenegro. So we have our own budget, state budget. We know exactly how much our budget is going to be for the next year, and we are not answering to anybody, to be honest. What we do is actually we have the public reports of on the basically it's like our annual report. We have quarterly reports, we have financial reports, and everything goes to the Parliament. But there is not much that they can do about it because we are controlling the MPs as well. So we basically sit within the system as completely independent regulatory body. It's really important that this kind of institution, they're not within the Prime Minister office or within any kind of ministry, such as Ministry of Police or Ministry of Interior or something like that. It's really important to be a regulatory agency or something like that, special office, and to be completely out of the system, such as our organization. And not just that, it's really important to have completely financial independence, which is also really, really important precondition. What is bad situation within Montenegro is that actually, even though we have the completely independent budget, we always have to ask for our money to the Ministry of Finance, which is approving or not approving certain things, such as employment of the new staff. But except that let's say minor issue that we currently have, and we are trying to fight it strongly within Ministry of Finance, everything else is quite well organized. So yeah, the best possible way is to have completely independent body.
I would say that since every agency has to report to somebody, you'd want to have the agency reporting to the legislature, to your parliament, which is the most democratic of the three branches of government in most countries, and where there's the closest connection with the citizens. Actually,
we have within the parliament, we have the special body, which is anti-corruption body, and they can always ask for clarifications and that kind of stuff, but there is nothing that they can do to the management of the agency. What they can do is actually to let's say change the members of the council of the agency. And that's everything that they can do. Actually, there is not much they can do. They basically, if they want to switch the management and that kind of stuff, they are usually powerless in that case. So only thing that they can do is actually to see this report, to make some remarks. But officially they only actually can change we have the 5 members of the agency council who is electing the director of the agency, and they can only change these 5 members of the council. They have to vote by majority of the present MPs, and that's all.
And another idea that should be looked at is lodging the anti-corruption program within the law enforcement program that the whistleblowers are reporting the crimes about. So like false claims was lodged within the Justice Department, who had the jurisdiction over it. And then it was buried within a branch of the Justice Department that dealt with frauds. Then they kind of adopted on their own, and all of the programs have a performance indicator system where they monitored their own performance based on the amount of sanctions obtained and the amount of rewards paid. And they could monitor that on a yearly basis. That's how we know that the laws have been truly effective, because all those numbers are published and we can watch the rise in the effectiveness of whistleblowing. So I would say the key is within an agency or a program that has a reputation for honesty and has an interest in the effectiveness of the program. And I would also say that you need to mirror that with objective performance indicators predicated on how many whistleblowers are coming in, how many sanctions, how many successful prosecutions, performance-based results.
And once people begin to see that the systems are working, the data that Steve's office and NGO have produced is overwhelming. Once you see the charts, the sheer impact, and it happened in the Republic of Korea and South Korea. Once they passed a whistleblower law in 2013 or 14, the number of reports skyrocketed into the hundreds of thousands, and the benefits to the country were in the millions and millions of dollars. So the impacts have to be publicized.
Yeah. And on that one, Mark, I just want to say that. So in the Commodity Exchange Act, which was a sleeper law, people didn't look at it as some gigantic program, but it really is, because it has worldwide commodities. When it was passed in 2010, by 2012, 2 years later, 50 people filed reports. 4 years later, they paid their first award of about $50,000. By 2021, 1,000 people coming into the program, and they paid in that year $200 million in awards. And you can track it, you just watch it. And it's just what Mark is saying, trust. Once you start to pay, once people's identities are really protected, once the non-governmental anti-corruption infrastructure, NGOs like Whistleblower Center or like Mark's organizations, anti-corruption organizations, lawyers, see this is effective, it just takes off. And that's what's so miraculous about this.
It's like if from that movie, if you build it, they will come.
Yeah.
And I can tell you that whenever we launch a new website, a new hotline, the calls start coming in. And as a person, I'm thinking about our society where there are millions of people every day going online to find out how to make a report. If you think about the several thousand people who probably contact Steve every year and the hundreds of people who contact me, think about the people who don't call. Like for every person who contacts us, maybe there's 100 or 1,000 people who want to, but don't. There are millions of potential whistleblowers all over the world, which tells you about how much corruption there is in the world. And this probably answers a lot of the questions about trust and capacity and how do you change attitudes and how do you build support. It's happening right now. If we had this panel discussion 10 years ago, there wouldn't be 400 people signing, it'd be 4 people signing up. Nobody would even know what it was. It's happening right now, right before our very eyes. The laws, the institutions, the NGOs, the investigative journalists, academia doing the research, new laws being passed. We need to just all work together in our own way to make sure that in each case, we have the best possible outcome, to limit the risks to the individual, to protect their identity, to make sure the information gets to where it needs to go. We haven't talked about investigations very much, but we need to get the information into the hands of the regulator or to the media. There's two halves to a whistleblower case. There's the retaliation half, then there's the misconduct half. What happens to the information? What happens to the evidence that we receive? We do something with every shred of evidence we get from a whistleblower or a citizen. We make sure that somebody in authority or a journalist or the police or a lawyer gets this information so they can act upon it. I make a joke, it's not very funny. Whistleblowers don't blow the whistle to see if they're going to be protected. They blow the whistle because they see a crime and they want something done about it. That's their only motivation, not to be famous, not to become a martyr, not to become a hero. They call for help because they see a crime, they want it to be fixed. There's one question about the distinction between whistleblowing about misconduct and whistleblowing about employee grievances. Typically, a law would not cover if you have an employee grievance, if your chair is uncomfortable or you didn't get your vacation pay or you didn't get your raise. That's not typically whistleblowing because it's an employee grievance. However, if you work at a big company and 5,000 people didn't get their vacation pay, or if you work at a public institution and there's massive discrimination against a class of people, that probably would qualify under most whistleblower laws because there's a public interest in knowing that these things are happening. We're getting to the end of our 90 minutes. Pawan wants to show a short film about a new course at the Academy. So I want to give Boris a couple of minutes to wrap up quickly, and then we'll go to Steve for some final thoughts. So Boris.
Thank you, Mark. It was really nice experience to be here today with you, and I was happy to read all these questions and try to answer some of those. As you mentioned, this is really hot subjects, hot topic. It's gonna be a lot of these kind of events in the future, and it's something that is heating up, and the number of whistleblowers is going to go skyrocketing, especially when this directive is fully implemented. And you know that only few countries, even that they breached the deadline, adopted actually this directive. And the best way to adopt it is actually to translate it, to transpose it completely within the system, because it's really good. And then what we will have in Europe is unified actually whistleblower rights. So whistleblower for one country will actually know if he has or she has some kind of a report that they can do the same thing within every single country, because the market is huge, and one country and one, let's say, company from one country is probably present in the more countries. So basically this, I agree with you, it's going to be a hot subject. It's going to be something that we should continue talk about it, and I'll be happy to share all my experience from the ground anytime. Thank you.
Thank you, Boris, and congratulations on your great work in Montenegro. It's a model for Europe, and we often refer people to the successes in Montenegro. Steve?
Thank you so much.
First, I want to thank the Academy again, and I also want to just point out the importance of the Academy's programs on this. As you can see from, I think we've touched on a lot of points here, but you can see how much more information is out there. Looking at the questions, you can see there's really a need to clarify and explore not just what we're saying, but the different alternatives, different approaches. There's a recognition that whistleblowing is key to anti-corruption. What there isn't is a real good working understanding of how to implement whistleblower programs, be it from compliance, be it from rewards, be it anti-retaliation, be it setting up a government program, be it how lawyers or NGOs should interact, be it how journalists should deal with it. So we can see we're really at this very major turning point. And that's why I just want to just thank, and it's not just PR here. The Academy has stood up. We did one class earlier this year. I thought it was fantastic because it gave us an opportunity to really explore these ideas in depth. I also just want to add that when you look at the academic literature and the empirical data, whistleblowing is the key to successful anti-corruption. And we know how bad corruption is. And so if we're looking at a tool that can be super effective, you need the knowledge and the experience and the academic backing to make that tool work. So thank you, Mark. Thank you, Academy. And I really want to thank all of the participants and excellent questions. Thank you.
Thank you, Steve. I sent Steve's PDF out on the chat. I hope everybody got that. I hope we answered all of your questions. We probably didn't touch on all of them in depth because there were so many. I sent you my email address, which is mwirth, MWORTH, at whistleblower-rights.org. I sent that out on the chat. Please send me any questions. All of us work with people all over the world every day to make this work better, to help people, to help our communities and our families and our countries to be cleaner and safer with more integrity. Please, we want to work with you. If you have a case, if you have a program, if you have an office, if you have a new piece of legislation or a new piece of legislation you're trying to implement, please send me an email today, right now, and we will respond to you and work with you in any way we can. So thank you, Boris and Steve. Pawan, I'm going to pass it back to you.
Thank you. We are going to start this in just 2 minutes. Okay, so thank you, everyone. Thank you, Mark. Thank you, Steve. Thank you, Boris. It was a great pleasure for us to bring all of you together and discuss this. And I'm sure that everybody will benefit from the valuable insights which have been provided. So from Ayaka, I thank all of you, and I hope that we will join again and again for similar things so that people all around the world benefit from such discussions. So thank you again. Bye-bye.
Thanks, everybody. Bye-bye.
Bye, everyone.